I think
Yeah.
we can start. Yeah.
Okay. So thank you everyone. So thank you participant to join this event. So as you know, today we are organizing this webinar on the topic admissibility of expert evidence in the court of law. So this is a very important topic for the forensic point of view because the students are generally study the many things about the forensic science, but the major aspect that sometimes lacking, that is the evidence, how to give the evidence in the court of law. Because after completing a degree, if you placed in any forensic science laboratory or work as a forensic scientist in the private. So it is a very important topic that if you prepare a report, so how you will present that report in the court of law and how it is admissible in the court of law. So for this, we are very fortunate that we have a very good expert on this topic, Mr. Anuj Kumar. He is a founder and editor-in-chief of Legal Desire Media and Insight. He is LLB LLM in the criminology and has a vast experience in the area of legal services and forensic science. So Mr. Anuj founded the Legal Desire Media in the year of 2013. He having a overall experience of 7 years in legal publishing, research, and in journalism. He is closely working with over 50 plus global law firms and even the individual lawyers in various practices for comprehensive legal research, practice management, business development, goals, and corporate communication. He has established one department, the Department of Forensic Science and Criminal Investigation, to pave a roadmap for next generation criminal investigation and mooting for the importance of mandatory inclusion of forensics in the legal academic curriculum. So this Department of Forensic Science that he has established, this publishes the India's first monthly international magazine, Forensic Reporter, having the international latest insights on forensics, interviews of forensic experts all over the world, case studies, criminal profiles, judgment, and many more things. He has been appreciated for his work by the international and national forensic investigating authorities, including the Central Forensic Science Laboratory, New Delhi Central Bureau of Investigation, Ministry of Home Affairs, and the various state forensic labs, international investigating bodies, police institution, etc. He is also an author of the one book, The Guide of Forensics in India Law, Investigating Crime in the 21st Century. Apart from this, he is associated with the Niti Aayog, Government of India as a mentor, Atal Innovation Mission, etc. And he is a member of the editorial board of these several national and international journals and has published a number of articles in the various international journals. So we are very fortunate and we welcome Mr. Anuj for this event, and we are very fortunate for your acceptance to give the expert talk on the topic. So thank you very much. Now, before proceeding to start this, I request our Dean, Dr. Sally Lucas, to say the few words.
Thank you so much, Dr. Prashant. And yes, it's a wonderful moment for me to get back to Anuj and get to hear him. Very young and dynamic young boy who has paved a lot of way for especially the forensic community and the newcomers, especially in forensic science. It's a wonderful opportunity to have been learning under his guidance. I think he's been very, very active in the forensic segment. I think more than law, Anuj, I understand it's more of forensic that you have got yourself into. And from the very topic that he has picked up for this session today, I think every forensic student who is part of the forensic program, they would understand that if not today, tomorrow, if they're going to practice in the world of forensic, definitely they would have to work as an expert and they would have to go to the court to give their expert testimony. And hence, I feel that this is a very, very important topic for all forensic students. And even for those students who would like to pursue a career in forensic, for them also, it's a very, very significant area that Anuj has picked up for today. In fact, from his legal background, with his legal background, I feel that he is the apt person to have delivered a talk on this particular area. So welcome on board, Anuj. It's wonderful, teaming up with you once again. And I think officially also we are partners in our academic build-up. Thank you so much for sparing your time. And I'm sure I'm going to see a very, very wonderful talk from your end. Thank you so much, Anuj.
Thank you so much, ma'am and sir. First of all, it is pleasure for me to be invited by my mentors, and we have also academic collaboration, and finally this topic. So even being in the law fraternity when I was in my graduate BLLB, so I was fighting for this topic as an optional for forensic, and then I still remember that I have to used to study with the medical student to learn about medical negligence, being a law student. So I was the only one in black coat and then with sitting with the white apprentice. So that is how I came into this field of forensic science and then developed the feeling that it should be aware and it should be promoted. And then I started legal desire, and then the idea of setting up a specific department of forensic science. And then we were joined by the mentors like Professor Sally ma'am and Prashant sir and others. So this topic is very important because I see the participants are from the forensic background, and ultimately it is the court of law which will decide the your cases, and that will give the credibility to whether it is admissible or not, whether whatever forensic evidence is there. So it is very important for you to also to understand about the legal part. What does our law say? Even Indian Evidence Act, what does the CRPC says, and what in how whose opinion can be admissible in the court of law, and what is the value of evidentiary value of the your opinion. So there are two terms: expert evidence, and then we have forensic evidence. So both things are different. In forensic evidence, we are mainly dealing with the evidence, the factual, the substances, maybe the physical evidence, something. In expert evidence, we are talking about the opinion, we are talking about the reports, we are talking about the testimony, and there is a specific list in CRPC also that is being provided who are experts, and we will understand whether only those the list is limited only to those expert, or whether the list is never ending. So in this session today, we'll be dealing with the expert evidence. What is expert evidence? Who are experts? Then what is the admissibility in the court of law? Its value and what does our law says? The Indian law specific, and then some judicial pronouncement from the Supreme Court and the High Court. So because we have only 2 to 3 sections, if we see about Indian Evidence Act, section 45, which provides for the admissibility of the forensic. And then we have judicial pronouncement, which has plays a roadmap for admissibility of these evidences. So expert evidence, generally, we have our Indian Evidence Act, and we have an opinion, it is our principle that generally the persons who are not relevant to the cases, so their opinions are not admissible in the court of law. But there is an exception to this rule, that is expert opinion. So our laws also recognizes these expert, and they can give an opinion on those subject matters. So there is a list is given in the CRPC also, and then we have section 45, which says about the expert evidence. So if you can see section 45, if I say what is the principle of the forensic science, it is totally based on the section 45. And when we talk about forensic science, then yes, forensic is admissible in the 4 areas: witness, admission of facts, and circumstances. So section 45 gives, we can say, it's open a gate for forensic expert and the other expert also to the court of law. So when the court has to form an opinion upon a point of foreign law or science foreign law, it doesn't mean only the international law. It means the laws that are not related to the that may be not in the knowledge of judicial officers, because they are also human. They have a limited knowledge about, so maybe they have a knowledge about the legal background, the legal thing. But for forming an opinion on scientific evidences, they also need some expert. For example, there may be a plane crash. So, if the court has to determine about the cause of the accident or the crash, they have to form a committee with having the technical expert from the maybe the air engineers or expert. So that is how we have this section 45 is very important. So it also give entry to the doctors, medical practitioners, and such. So these persons which are very specifically skilled and in such foreign laws, they are referred to as expert, and then their opinion is said to be expert evidence. So now who can be expert? So if we say about if we read the section 45 in explanation part, we can say that expert is a person who has a special knowledge, a skill, or experience, or either in the following subject: foreign law, science, arts, handwriting, or fingerprint. And then we have such knowledge or like that he or she can gather from many experiences, observation, or proper studies. Now there is a question like which has been referred to many cases, like whether a formal degree is required for an expert opinion, whether only MBBS or whether only like the forensic expert with a forensic degree, can only they give the expert opinion. So like we have firstly section 293 in CRPC. So there is a complete list like who can give opinion, as you can see on the screen, like the director of fingerprint bureaus, and then deputy director and assistant director of CFSL, FSL, and there are other person in this list, serologist to the government. Now these are the persons having a degree with them, having a skill degree with them. So now if the court has to form an opinion whether they will be limited to only this section only, section 293. So this question has been raised, and then it has been also addressed by the court of law. So we have a judicial pronouncement, like for example, like our question was, are formal qualifications are necessary to qualify as a witness, as an expert? So there is a case, as you can see, Mysore High Court in Abdul Rahman was state of Mysore. So where the opinion of a professional goldsmith as to the purity of the gold was in question. So it was held that the person having experience in goldsmith, so although he has not formal qualification, but because he has gathered his experience, he has gathered his skill from his experience, so it will be also relevant to the court of law. So they can also form an opinion. Then again, there was another case. It was held by the Supreme Court that in a conviction for causing a death by dangerous driving, where there was no eyewitness, and the accused himself had no recollection because of maybe medical conditions, so he was not gathering the knowledge about the cause of incidents. The prosecution called a policeman from the traffic department having a considerable experience with the qualification accident, and his opinion was then again admissible in the court of law. So this is how like we can address this question. So there are no formal qualification necessary, but yes, if we go back to this slide, so we have to observe this part, like practice, observation, and proper studies, so that you can gain that knowledge by experience. So like the police officer was having an experience, like he was dealing with the cases of being in a traffic department. Similarly, goldsmith was in that case was having a experience of goldsmith. So these things are also necessary, not only your degree. So there are other things also that will play an important part. So this is about the experts and who can give opinion. Now let's talk about the admissibility of like let's talk about the law firstly. So like we have section 45 which provides for these things, and then apart from that, like we have an amendment after the insertion of like section 45A, which was inserted by Information Technology Act, because now we can see also there are electronic evidence also there. So like electronic evidence as an expert can be there. And then we have section 46, which provides for the relevancy of such facts, whether these are admissible or not law. So in and all, if you have to read about the law part, like you have to read about the Indian Evidence Act, and from section 45 to 51. So these talk about the relevancies of expert opinion. So very important for forensic student also, like you have to read all these things, because in and all, when you will go in court of law, these sections will be then raised by your opponent party. Maybe the criminal lawyer side. So like you will be from the prosecution party, you will be preparing the report, and then there will be these like sections from the other party, and then you have to then again convince the judges whether your opinions are then admissible or not. So these are the sections, and then yeah. So whether expert opinion can take the place of substantive evidence, again an important question. So in short, like it can't take the place of substantive evidence. So, but in absence of that substantive evidence, these can play a primary role. So like in the case of Basu Prasad versus other and state of Bihar, like these are two cases, it was held that even the expert opinion is relevant, appreciation of evidence is a court job. So ultimately, it is in the discretion of court whether that expert opinion will be admissible or not. So like there has been many instances like where the expert opinion has been neglected because of the relevancy of the direct evidence. So there has been so many things. Now the Honorable Supreme Court has laid down in quite a few cases that the evidence of an expert as to handwriting is only in the nature of opinion, and it can rarely take the place of substantive evidence. So, but it should be corroborated either by clear direct evidence or maybe an expert. There can be handwriting expert. So then such evidence can be admissible. But a simple, we can say the expert opinion can't take a place of substantive evidence. So if we compare the weight of expert opinion, substantive evidence, so always the substantive evidence will be higher. So now we come to the point value of expert opinion. So yeah. So like we have talked about the admissibility part, and then we are talking about the value. So what is the value? Like if it is not that much admissible in the court of law as compared to the substance, then why we have expert opinion in our court of law? Now there are some factors, like if you, so it is a very landmark judgment on value of expert opinion, State versus Walker, and there are two cases. So combining all together, the court has given some quotations like by the justice. So firstly, there is a danger of error of a deliberate falsehood, because this privileged person means the experts, because they have a knowledge, because they have a degree. So that is why the court is calling them as privileged person. So this privileged person might be blind, incompetent, or even corrupt. That may be the chances of the corruptions can be there. Secondly, his evidence is an after all opinion, and they are also human, and human judgment is fallible because it is no scientific judgment. Human knowledge is limited and imperfect, so no man ever can master all the knowledge of any sciences. So the thing that you are seeing in the quotation are said by the justices in both the cases. Then thirdly, it must be borne in the mind that an expert witness, however impartial he or me is to be, likely to be unconsciously prejudiced. Like the other thing that can be like he will obviously take the side of the person who are paying them, and then there can be chance of corruption also. There can be any undue influence can be there, and then there can be human error. So it is based on these factors that it has been demarked an expert, that the witness now in the worst step to are called expert witnesses, because we have, if we see the condition of the Indian court of law, then again it is very easy to find experts. You can find handwriting expert, you can find other experts over there, and you can also find like the false witnesses also very easily. So that is how the court give more importance to the substantive evidence as compared to the expert opinion, and this is how the value of expert opinion is there. And then we come to the part about the judicial pronouncement. So there are various cases like constitutionally, like this is a very important question again, like whether it is constitutionally there, whether it has a constitutional validity or not. So like, because when we talk about the forensic evidence also, and also about the expert opinion, like now we are only talking about the scientific part also. For example, you are a forensic expert, you are taking a fingerprint, you are taking handwriting samples, you are taking any DNA sample. So then there were cases and there were questions that whether it is constitutionally there or not, because we have Article 20 subclause 3 in Constitution of India, which provides that you can't hold a person liable like for self-imprisonment. So you can't take evidence against himself. So then again, this question was referred and addressed in the state of Bombay versus Kathikalu, and it was held that whether the question was regarding fingerprint and handwriting samples, the court held that the compelling the accused to provide fingerprint and handwriting samples under Section 73 for the like Section 73 of the Indian Evidence Act for the purpose of expert opinion was not hitting 20 subclause 3. So hence you can take the like fingerprints, you can take the handwriting sample. But if we compare it to the narcoanalysis test, so this was something that is physical. Now we are talking about the mental part, because in narcoanalysis we are then again injecting the truth serum. So in this case, again, the narcoanalysis was held unconstitutional because the court compared about the personal liberty also, because now we were only talking about the Article 20 in our like the first part. Now, if we talk about the narcoanalysis part, it is also about the personal liberty and right to life also. So then again, it was not only infringing about the Article 20 subclause 3, but also hitting the Article 20 Article 21, right to life and personal liberty. So that is how this was held unconstitutional. And again, like although we have a culture that our state government and the police, they can die for the narcoanalysis, but then again, ultimately, like consent has to be given from the accused or from the victim, and then you can only proceed. And then also ultimately, it is in the discretion of court of law whether it is admissible or not. So another case we have, so there can be situation when there can be like medical evidence cannot override reliable direct evidence. There can be medical opinion also, and there can be direct evidence. So in that cases, if direct evidence is satisfactory and reliable, the same cannot be rejected on medical evidence. Might be because of the nature that might be that medical opinion can be a result of a like corruption, or maybe an undue influence, or maybe the person is taking the side of that person. So then in this case, again, Supreme Court held that if direct evidence is satisfactory, then there is no need for medical opinion. There can be cases like there can be conflict in the opinion of two doctors. Might be two persons have worked on the same cases. So there could be situation that doctor opinion themselves vary in the question, and whose evidence should the court will accept. Then again, the court also addressed this question in Maju versus State of NP. The doctor who examined the injuries immediately, the first doctor. So the doctor who first examined them and described the nature of injury, which were fully in conformity with the oral evidence given by the eyewitness. So that will be admissible in the court of law, not the second one, because he was the first person who met with the victim and was done the analysis of all the injuries. So his or her opinion will be considered. So again, very important for forensic expert. So if you are going on a crime scene, so like if there is again a conflict of opinion, might be possible there is State Forensic Science Lab and Central Forensic Science Lab, maybe 2 or 3 teams are there. So whose opinion will be considered? Might be possible there can be persons from like a private investigating agency can be there. So then again, these judgments can play a role of precedent, and ultimately then like you have to convince the judges. Now there are also things when corroborations are not necessary. For example, in handwriting also there are things. So like we have in like a Latin term called res ipsa liquitor in law. So it means the thing speaks for itself. Like if judges are like, we can see from our eyes that yes, this is the case. So like there is no opinion is required. For example, like there is a burning of house and we can see a can of like kerosene and something. So like we can say that yes, this is a cause of like firing and something. So that we have a opinion. Similarly, like there is a case Ram Naren versus State of Uttar Pradesh. So then again, Honorable Supreme Court upheld the conviction of accused on a charge of kidnapping on the basis of evidence of an expert that the letter by which ransom for the child was demanded was in the handwriting of the accused. So Justice Dua was presiding this case, and he himself compared the handwriting in question and compared with the proven handwriting of that person and satisfied himself. So there was no further corroboration was necessary. So there was no need to like we can say hire any expert to do the analysis. So like if corroboration is not necessary. So if you see all the cases, means you have to convince the judges. Ultimately, it is the court of law, so which has the discretion. So corroboration won't be necessary. Then again, we talk about like if we talk about handwriting. So then handwriting may also be proved by the evidence of a witness in whose presence the writing was done. For example, whenever you sign an agreement, whenever you sign any MOU, say there are always witnesses over there. So you have to sign those MOU, you have to sign those agreement when you buy any property, when you do maybe a court marriage certificate or something. So there is always witnesses. So what is the purpose of those witnesses? Because they know they can testify in the court of law that yes, you were present during that time, and yes, this is the handwriting of that person. So even if those persons are present over there in the court of law, so they will be given primacy as compared to any handwriting expert. So if those witnesses are present and they can give a statement in the court of law, yes, we were present, we were their witness, and you can testify in the court of law, then again, you don't need any expert over there. So the person, evidence of a witness in whose presence the writing was done, and this would be direct evidence. So it will be considered as a direct evidence, not expert evidence. And if it is available, the evidence of any other kind, maybe any handwriting expert is there or another, so that will be rendered unnecessary. So very important why we have witnesses column in the MOUs and agreements. So this is the purpose, so that we can the court can testify again. Now, if we conclude all these things, so it means an expert may give the evidence of the experiments conducted by him, like if we talk about the forensic part, the scientific one, for the purpose of forming his opinion. By looking at the grounds, the court can determine the soundness and credibility of the opinion. And therefore, from this point of view, the grounds are especially important and such relevant. So if we conclude all this thing, we can say that like you have to convince the judges first, and there can be evidence of many nature, and you should have skills in that. Like if you have to convince the judges, firstly you should have skills if you are coming as an expert, and you have to form your opinion, and you have to give the reasons why your expert opinion should be counted and why not other type of evidence. If there is a direct evidence, then there is nothing that can stop the court of law to pass judgment on this substantive evidence. But in absence of any substantive evidence, you can play the role of you can form the court opinion by convincing them. So this is how, like, you can do, like, for example, let's take example of MLR report. Like medical legal reports are there. There are various columns in that medical legal report. Let's take example of toxicology cases. So in medical legal report, the doctor has to enter so many things, like about the type of the toxic or poison taken from where and other things. So you have to fill all these things, and might be possible you have missed out some special particular, and the opposite party, because they will hire a criminal lawyer, so definitely they will come after you. So if they are able to convince the judges that the medical legal report lacks some important guidelines or important particulars, so ultimately you will lose the case, and even that doctors can lose their license also, because they are not adhering to the guidelines. So very important for the doctors also. And the court can also make it mandatory for the attendance of the doctor in the court of law, and they have to then again testify, then do the cross examination. So whenever you are writing a report, like you are forensic students and will be becoming a forensic expert in near future, you have to take care about all the guidelines. You may have SOPs, like there are SOPs given by Ministry of Home Affairs and State Forensic Science Lab. What are the particular of forensic report? Like for example, a post-mortem report, what should be there in the post-mortem report? For ballistic, what should be there in the ballistic report? The size of bullet, the velocity and other thing. In toxicology cases, like also we say in our language, in our court law language, like we have given a term called 8Ks. 8Ks means like kab liya, kitna liya, kahan liya, kisse liya. So about the toxicology nature. So like you have to you have to fill all this particular, because you have to also think from the other side, because the other person want to save his client also. They are also professionals, though they are not in like scientific field, but they also having a complete battery with them of the lawyers, and they will also read about it. They will also come with the proper research in the court of law. So they will also like maybe might be possible they will also hire a private investigator or maybe a doctor to cross-examine your report. So they will also come with the preparation. So whenever you are preparing any report, so you have to be prepared that this report can be in the court of law anytime. So whether the case may be not of serious nature, but every case is serious when it is coming to you, and when you are a forensic expert, you have to be prepared for that last day, that this will be ultimately in the court of law, and you may have to go to the court of law, because the court can, if the opposite party, they are able to convince the judges that there is something fishy in this report, so the court will make it mandatory for your attendance in the court of law. So the person who has prepared that report, ultimately you have to go in the court of law, and then again like you have to convince the judges, and if you are not able to do, then there can be actions against you. If there can be like they can find out that something fishy is there in your report. So you have to be prepared about all this particular thing. And that is how, like, we trust CBIs, we trust NIA, because we have a trust on them as per their skills, and because we also know that there is ultimately judiciary is there. If there is any something there in their report, so the court can take actions against those officials also. They are not above the law. And that is how, like, still we have like when we talk about the nature and the qualification of judges. So like the judges, when they are trained in the JTRI, that is Judicial Training Research Institute, after they pass their examination, they also have some forensic knowledge. They also have the forensic workshop and training. But as compared to forensic expert, they don't have such knowledge. So like we can say, it is very sorry state of our India also that our court of law, they are not well versed with the scientific terms, And that is why we are also voting for a mandatory inclusion of forensic in legal academic curriculum. And also the legal academic curriculum should be mandatory there in the forensic student curriculum also, because they have to again in the court of law, and you should also read about the laws, especially the Indian Evidence Act, CRPC provision, and IPC, Arms Act if you're dealing with the ballistic, if you're dealing with the toxicology things. So then again, drugs and other acts will be there. Narcotic and psychotropic substances act are there. So like both things will go hand by hand, forensic and law. So they are complementary to each other, and then only like we can meet the end of justice. And it is very important for the lawyer also to understand about the forensic the part, the scientific knowledge. If you are a criminal lawyer, then you should have a forensic knowledge. Else, like then you can do the other type of cases. Like you can go in the civil nature cases. But if you are dealing with the cases of criminal nature, and it involves the forensic science, even if it doctors, then you should have knowledge about the forensic subject. If you are a forensic expert, you are dealing with the cases, then you should have a knowledge, sound knowledge about the legal part, at least that legal part that is there in your like your purpose, Evidence Act, IPC, and other act. And also it is for the judges also, like when we are trusting them for deciding the cases, so they should have a sound knowledge about the forensic part. And that is why section 45 is there to help them. That is why the purpose of this like webinar is also there, why we are talking about expert opinion, because of the lack of knowledge between the like the judiciary part also, because also they are human and they can't process the all type of skills. They can't process the skills in the forensic, they can't like process the skills in the toxicology, or maybe other type of like natural disasters. So that is why these committees can be formed. And this section 45 is very important of Indian Evidence Act. It gives entry to everyone like who are experts, and it can so they like expert opinion is to assist the judges, not to decide the to decide the cases. So like we have to draw a line between the expert opinion. So it is to assist the judges and not delivering the judgment. So whether or not that is ultimately in the hands of court of law. So whether these like opinions can be accepted or not, then it can be again testified by the corporation or by any other committees. So there is provision also for forming committees, like we are when there are cases related to sexual harassment or when we rapes. So we see the state government is forming an SIT. So SIT is also then again consist of the expert. And then when we say that the family of that victims, they want CBI committee, they want a committees which is headed by this Supreme Court or the High Court judges. So because of the expert opinion provision only, so these things are important. So though it is not completely, can't take the structure or the nature of the substantive law evidence, but still it is very important. It has a value. And ultimately, when we are going in the technological age, so we need like expert opinion. So that is how this like expert opinion plays an important role in even in the law part also, and even in your forensic part. So this is about the this